Sometimes a defendant's actions result in injuries and losses to plaintiffs located in multiple states. Is it proper to combine these plaintiffs' claims into a class action governed by the law of one state? We explore this complex issue in the case In re Bridgestone Firestone Tires Products Liability Litigation. In the late 1990s, the tires on Ford Explorer SUVs experienced high failure rates, resulting in injuries and deaths. Lawsuits arising from these failures were filed throughout the country. The plaintiffs in these suits fell into two major categories. First, there were those plaintiffs seeking damages related to injuries and deaths from tire failure. Second, there were those plaintiffs seeking damages for the risk of failure. For example, if a person had purchased her vehicle at an inflated price and then had to resell that vehicle at a depressed price, she could be seeking compensation for the vehicle's diminished value. Ford had its headquarters in Michigan, but many of its vehicles were manufactured outside the state. Similarly, Firestone had its headquarters in Tennessee, but many of its tires were manufactured outside the state. Pursuant to 28 U.S.C. Section 1407A, the Judicial Panel on Multi-District Litigation transferred the suits to the Southern District of Indiana for pretrial proceedings. At the conclusion of the pretrial proceedings, the cases would be remanded to their original jurisdictions for adjudication on the merits. Many of the plaintiffs joined to file a separate consolidated suit against Bridgestone Firestone Incorporated, Bridgestone Corporation, and Ford Motor Company, who we will refer to collectively as Bridgestone. The plaintiffs asked the court to certify the suit as a class action, which would render the underlying suits redundant. The court certified two nationwide classes, one for the owners and lessees of Ford Explorers and the other for the owners and lessees of the relevant tire models. The court stated that under Indiana's choice of law provisions, the governing law would be the state of the place where the defendants had their respective headquarters. Therefore, Michigan law would govern the Explorer class claims, and Tennessee law would govern the tire class claims. Bridgestone filed an interlocutory appeal, arguing that a class action wasn't proper.